Right out of the gate, this case hits hard. A 35-year-old man is accused of driving a BMW from mailbox to mailbox, allegedly stealing mail during tax season, the exact time families are waiting on refund checks they may be counting on for rent, groceries, school clothes, or bills. And that one detail changes everything. Because this isn't just random theft, it suggests timing, planning, and targeting people when they were most vulnerable. Now, today's hearing isn't about whether the accusation sounds bad. It's about what happens after the defendant enters a plea agreement in a felony case involving theft of mail and identifying information. The judge is about to walk through rights being waived, punishment ranges, and whether this man deserves another chance or prison time. But here's where it gets interesting. The defense will argue he's trying to improve himself. College, employment, working toward a better future. The prosecution? They're about to bring up a criminal history that could destroy any chance at leniency. And then comes the moment viewers always remember. The judge directly confronts him with one brutal question. Why are you driving a BMW stealing people's mail? That question cuts deeper than it sounds. It's not about the car. It's about choices, priorities, and whether someone with options chose crime anyway. Stay locked in, because this hearing turns from routine plea paperwork into a full reality check. And I want to know early, do you think someone trying to rebuild deserves mercy, or does a repeat record end that conversation completely?
Why are you going around in a BMW driving to people's mailboxes and taking their mail? And I did note in there that you took the mail during tax time. So that means that you knew that people were receiving their income tax and you took their income tax checks. So why are we doing this? Court is calling 2022 CR 2437 State of Texas versus Rudy Mayfield Lopez Schilling. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Sunny Middleton.
And are you Mr. Schilling?
Yes, Your Honor.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Yes, Your Honor.
I
Yes,
said
Your
yes, Your Honor. Please stop.
Court will find that the state is in compliance with discovery. Mr. Schilling, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Schilling, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Did you understand you're charged with theft of mail, identifying information? Is this greater than 10?
Less than 10.
Less than 10? Less than 10 addresses enhanced. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand that this offense is a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Schilling, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
This is one of the most important parts of any felony plea hearing, and many people overlook it. The judge is making sure the defendant fully understands what he is agreeing to before the court accepts anything. We just heard that punishment is set at 4 years in prison, along with a fine structure, and that the state opposes community supervision. That means probation or deferred options are already facing resistance before sentencing even begins. The court is also confirming he waives certain appeal rights. That matters because once a plea bargain is accepted and rights are waived, options afterward become extremely limited. In simple terms, today's decisions carry real consequences that are hard to undo tomorrow. A lot of viewers think plea deals are easy exits, but they're often calculated damage control. When evidence is strong, defendants sometimes choose certainty over risk. But was this smart strategy or just the least painful outcome available? Let me know what you think.
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There is a $1,000 fine probated. State opposes your application for community supervision or deferred adjudication. They will take in consideration night mag number 628298. Did you understand that to be the plea bargain agreement?
Yes, ma'am, Your Honor.
Defense, is that a plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, sir.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
Yes, state offers states exhibit 1 in its attachments.
No objection.
Mr. Shirley, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Now the court will defer finding of guilt issue apply for deferred adjudication. Would you like to proceed with sentencing?
He would like a PSI, Your Honor.
All right. I need a date for PSI. July 26th.
Your Honor,
Yes.
my client would just rather you would go ahead today. PSI.
All right. So, Mr. Schilling, do you understand that without a PSI report, I'll be proceeding over whatever information the state presents and your attorney presents to me? Do you understand that?
Yes, Your Honor.
And knowing that, do you still wish to go forward with your PSI?
Yes, Your Honor.
I'm sorry, with your sentencing today?
Yes, ma'am, Your Honor.
And here comes the prosecution's strongest weapon, not emotion, not speculation, but pattern. The state lays out prior convictions, prior theft cases, even a previous chance through deferred supervision that ended in revocation. That's devastating in a sentencing hearing because judges often ask one question: what happened the last time we trusted you? If someone previously received leniency and still reoffended, prosecutors use that to argue rehabilitation attempts already failed. They're essentially saying, we tried mercy before, it didn't work. That can be more damaging than the current offense itself. Now the defense is about to counter with education, employment, and self-improvement. Those are meaningful points, but the court must weigh future promise against past conduct. That tension is where sentencing decisions are made. Be honest. If you were the judge, would you focus more on who he says he is now, or who the record says he has been for years?
All right, state, you're opposing the application?
We are a judge. And our opposition is in part due to the nature of the offense, but more so because of his criminal history. Specifically in 2014, he was convicted of aggravated assault. He was placed on deferred for 4 years, but ended up being revoked and was sentenced to 4 years. He also has prior misdemeanor theft convictions for theft from 2009 and 2015. He's been given an opportunity at deferred, and he has shown that he is not a good candidate for it. We do not believe that he would be a good candidate now, as his criminal history goes back over 10 to 15 years. So that's why we're opposed.
All right, defense?
Your Honor, that is true. Mr. Schilling has been trying to better himself. He has an associate's degree. He's in college right now, or he was before he got picked up. So he's gonna have to, restart a couple classes. He's trying to get his bachelor's degree. He understands what he did was wrong, and he's trying to make himself better. He was employed, like I said, and in college, and he's trying to become a better person. We're asking for deferred to give him another chance. You always have the option if you were to screw it up. I mean, we all know he can be right back here and then be sent to prison.
All right, how old are you?
This is the turning point of the entire hearing. The judge is no longer discussing paperwork or legal procedure. She's confronting the human impact of the crime. Notice how she reframes stolen mail into real victims: families waiting for tax refunds, parents buying clothes for children, people planning necessities or small joys. That's powerful because it transforms mail theft from a technical charge into stolen opportunity. Then she challenges the defendant's remorse. She points out that regret after getting caught is not the same as regret during the act, especially when multiple mailboxes were allegedly targeted. That distinction matters in court. Judges look for accountability, not just apologies timed after arrest. This is also why courtroom moments like this go viral. It's not yelling for drama, it's moral clarity. The court is asking, were you sorry for the harm or sorry for the consequences? That's a question bigger than this case. What do you think? Was the judge being tough but fair, or too harsh in that moment?
35, Your Honor.
You're 35. Why are you going around in a BMW driving to people's mailboxes and taking their mail? And I did note in there that you took the mail during tax time. So that means that you knew that people were receiving their income tax and you took their income tax checks. So why are we doing this?
Your Honor, I have no good excuse. It was a bad choice. And I really do regret.
No, I
what
mean, I know
did.
you understand bad choice and people have regrets once they get caught.
Right.
But you were not regretting it as you were doing it because you did more than one mailbox in that same day.
Yes, ma'am.
So where was the regret then?
There wasn't at the time.
Because what I have here is, they received a call in reference to someone operating a black BMW who were stopping at the mailboxes along the roadway and taking the mail. So all of these people, you took their mail, they were expecting an income tax check, right? So they had paid their taxes, they had filled out their taxes, and who knows what they were planning on doing with that money. Maybe they need to buy clothing for their children for school. Maybe they're just gonna go on a little vacation, but you took that away from them. So why should I even consider giving you deferred adjudication or regular probation? When you've done this before? How many thefts have you committed in your past before? That you've been caught for?
Twice,
I'm sorry,
I think twice.
you see how long it took you to think about that?
Yes,
Do you
ma'am.
know what would happen if I asked your attorney or asked the state attorney how many cases they've had for theft before? You know how long it would take them to answer that?
Yes, ma'am.
Right away, they'd answer it. Is there anything else from the state or the defense?
Nothing from the state.
No, Your Honor.
All right, I'm gonna find you guilty.
And there it is, the final ruling: 4 years in prison with credit for time served. After reviewing the plea agreement, the criminal history, and the facts presented, the court chose incarceration over another chance at probation or deferred supervision. The message is clear: Repeat theft behavior, especially involving people's mail during tax season, is not something this court was willing to excuse. The judge also reminds him of the long-term consequences of a felony conviction, including loss of firearm possession rights and limited appeal options. Those collateral consequences often last far beyond the prison sentence itself. This case is a textbook example of how prior records can outweigh present promises. Education and future goals matter, but courts also demand proof through consistent lawful behavior. When second chances have already been given, third chances become much harder to earn. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I'm going to sentence you to 4 years in the prison. Give you credit for any time served. Take in consideration NIMAG number 628298. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Don't steal. Don't take what doesn't belong to you. People work hard for what they have.
Yes, ma'am.
All right, good luck.